Welcome to students, teachers, alum of the We the People program, and the generally curious to the Constitution and American life with the Friends of Publius. I am David Richmond, your host and bus driver, and as always, we have Professor Tim Moore from the Center on the Study of the Constitution, from the Green Bay Packers State, Professor Chris Kavanaugh, a naturalized Hoosier and Cowboy fan who now takes up space in North Dakota. And finally, the babe magnet of the band, Dr. Professor Mike Williams from the University of San Diego. To those who might wonder, neither myself or Professor Williams are in danger of fire at this moment, but given the conditions of Southern California, the dryness and the winds, we never know. We'll keep you updated. Before we begin our discussion on the fallibility or infallibility of the Supreme Court, let's take our weekly journey to this day in history and find out if our friends believe that the event is a need to know, nice to know, or nuts to know event in human history. On this day in history in 1943, leaders of the Allied powers meet at Casablanca for the first of the wartime conferences. Is this a need to know, a nice to know, or a nuts to know event in history? And I believe this is right down the middle of the strike zone for Professor Williams. So, Mike, need to know, nice to know, or nuts to know?
I don't know.
That wasn't one of the options.
I know it should have been. It should have been. I'll say nice to know, and just because I'm going to go in the middle. I don't remember. Look, you don't prep us on these things. I don't remember. I don't know what the historical significance of that off the top of my head. I have to look at my lecture notes. So,
and it's probably not a subject. I guess if you taught a foreign policy and political science, I guess it might be important. But in comparative politics, I don't know if that subject comes up.
It doesn't for me. Not the way I teach it. So, I'm gonna pass it along to my friends.
Professor Kavanaugh.
It's nice to know. I mean, I think it pales in comparison to, say, the Tehran Conference and Potsdam. Obviously, Tehran sets the stage for post-World War II, and Potsdam is the meeting with Truman, filling in for FDR at the close of the war. Casablanca, I mean, it's interesting in the fact that you have, three giants of the 20th century in Churchill, FDR, and Stalin. And FDR was not ill like he was in Tehran. And there's that famous photograph of where he's sitting between Truman and Stalin.
Is that Yalta or Tehran?
Oh, Yalta. I'm sorry.
Yeah.
Yes, Yalta. I don't know why. Yes, thank you, Tim. Yalta. It was Yalta. So he was able to use, FDR was still healthy enough to use his power of persuasion to make sure that those two didn't strangle each other at Casablanca. Yalta, in Yalta, you could see that he was not long for this world, and he wasn't. So it's nice to know, but not as important as the other two.
Professor Moore?
Yeah, I'm going to go with, just to be a little contrarian, I think you need to know. I'm going to go there because if I'm fuzzy here, Chris, it was at Casablanca where they decided basically two things. One was unconditional surrender was the goal of the war. And then the other important thing, I think, was how they would proceed through Europe with forces. And I think I can keep a straight face when saying that unconditional surrender was important largely because some of the dissatisfaction of the ending of World War I. And where it was armistice, ceasefire, so to speak. So I think a commitment to unconditional surrender, and what that means is a full-scale invasion into Europe, and then so I'm maybe not full-throated need to know, but pretty close. But certainly Yalta, I would say, is definitely in the need to know, because were there 4 or 5 meetings during the war?
No, there's the big 3. There's Casablanca, Yalta, and Potsdam, but you also have the meeting with Churchill and Roosevelt before those.
Yeah, the Atlantic Charter.
So there's the big 3. I believe, there, and Chris kind of talked about Potsdam and Tehran there. I'm going to pull a Tim Moore, and I'm going to say it depends. If you're teaching a kind of a military, a focus on a military history kind of course, then it might be between need and nice. In a general survey class, it's nuts to know, just the general idea that the Allies met together to make some plans. But as far as the specific conference and where it was, I think it's kind of nuts to know in an American history class in which you have to teach all of American history in one academic year. So that's my splitting hairs on that. So hopefully that was an enlightening discussion for those who are watching. This evening, we're going to carry on with your enlightenment. This evening in our episode 4, we are going to be addressing Unit 4, Question 3 from the We the People National Finals question, which asks students to address the concerns that the Anti-Federalists had regarding judicial power and whether or not it is accurate to say that the court is the last or the final arbiter of what the law is. So we're going to shake up the lineup tonight and begin with Professor Chris Kavanaugh, who has an illogical love affair with losing professional sports teams here. So we'll start with Chris, a Cub and Cowboy fan. I guess there's a C in both, so there's a theme there other than they're losers. But in the past, they were once great, but today they're losers. Anyway, Professor Kavanaugh.
Well, I just would go on record that my baseball team has actually won a series, more so than maybe a couple other people other than David. So anyway, just
you including Professor Williams on that? I think you're saying other than one person, because I think Professor Williams, they've won 3 series in the 21st century. Is that correct, Professor Williams?
Oh yeah, 3.
Yeah, but in the words of Janet Jackson, what have you done for me lately?
Wait, we won our last one in 2014. You won in 2016.
So we're much more modern.
Oh my gosh.
Okay.
Okay, let's get to the Federalists, Anti-Federalists, because their arguments make much more sense.
Yeah.
Wait. Are they need to know or nice to know or nuts to know?
Well, we're going to find out here. So, Chris, it has been said that Article 3 created a uniquely American institution by having an independent judiciary with lifetime appointments. Would you agree that the American judicial branch is unique? And I'm going to kind of give you a time frame, because today and in the late 20th, it becomes very common. But in the 18th, 19th, is it unique? That would be centuries. Is it unique?
I think so. When it was created, it was different than what they had seen in from England, and if you go far enough back, my gosh, I mean, you've got the Saxon influence and then the Norman influence on common law in Great Britain. And for students, you wonder why we have so much French jargon, French words in our judicial history, is because it's taken from the Norman law and Normandy back to World War II for the idea of the Norman section of France. So, like petit jury and voir dire and other terms that, so, but back to your question, David, I think when it was instituted, well, let me back up for a second. I think in the Constitution it's in the Constitution, there's going to be one Supreme Court. And we know that these people will be appointed by the president. The judges will be appointed by the president, confirmed by the Senate, using their advice and consent power. And they'll be there for a term of good behavior. What their role will be is and how it will look is kind of unclear. So I think students, make sure you're paying attention to the Judiciary Act of 1789, September of 1789. It's one of the first things the first Congress will deal with, is to put some, we call them framers of the Constitution. So these guys are going to be coming in and put some drywall up and maybe some electrical and plumbing to finish the job. So the Judiciary Act of 1789 really helps establish our federal court system. And it doesn't get changed until like 1891, where they put in another level of appellate courts. So yes, it was at the time, it was different in terms of lifetime appointments. And of course, we get to Marbury in 1803 and finally establishing that third leg of the bar stool and using the power of judicial review, even though that I think the framers and anti-federalists knew that judicial review would be used. I think what's concerning or disconcerting is we've left our court somewhat frozen in time, and other courts around the world at the time we were unique, even compared to maybe some of the stuff that was going on in Great Britain and in Europe. But what's happened now, the rest of the world has moved forward with redesigning court systems. I don't want to get too far afield here and step on any future questions, but we have not. And we used to be able to amend the Constitution to fix changes or to fix issues that we believe we have problems with, to change the Constitution. And now that seems almost like an impossibility. So we rely on the court, and the court itself is still the court that basically that we get in the Constitution and the Judiciary Act of 1789. So at the time, yeah, we could pat ourselves on the back for having a very interesting third branch of government, if you will, an independent judiciary that was able to strike down.
Is that where the true essence of the uniqueness lies? Is that it's independent or
Yes.
allegedly independent?
Well, I see Tim is wincing here, but I think when you compare it to the world at the time, it was a level of independence, and are people true? I mean, we like to believe that they're independent, therefore they're above the political fray, allegedly. But now I think the world, many cases have kind of passed us by in terms of, okay, we're going to have this court for constitutional law, and then these other courts for determining statutory law, right? So, I don't know.
And one other quick one before we get to the Windsor from Wisconsin. You brought up something that I've gone around and around with multiple people, and that is you said they didn't quite know what the Supreme Court would do. Did I understand you correctly on that? Because I thought, what else would they do if they weren't going to have review?
Well, I think both Federalists and Anti-Federalists knew there would be judicial review. Judicial review already existed prior to the Constitution, right? I guess I misspoke. And the idea is the Constitution itself doesn't really prescribe. It gives the Supreme Court original jurisdiction and appellate jurisdiction, both the cases, cases in controversy. And we know that through the years, with various judiciary acts, they've eventually been able to establish their own docket. There were a number of cases that they had to hear through the years. I think it was the Judiciary Act of 1925, 1924, that allowed them to set their own docket, which gave them a much more ability to hear the cases they wanted to hear, not necessarily have to hear. And this is, I mean, for the students that dive into this, you can take a look at the number of cases that the court was hearing at the turn of the last century they had to hear, versus what they, in a good year now, they may hear 70 cases. So that docket has changed. But my point in saying that, David, was that the Constitution itself does not come out and explicitly say this is exactly what's going to be. This is how many justices. This is how this is all going to work.
All right, Professor Moore, did you want to?
Yeah, I mean, Chris's point is well taken, but again, it's always the devil's in the details of how the phrase judicial independence is actually operates. You see, I think it might be helpful for students to think about this distinction. Back in that day, they could say judicial independence and have an expectation of some kind of checks on the court. They believed there was judicial independence, even if there were checks. Like New York, there was a council that could overrule their Supreme Court decisions. So, and that's true in Britain too, with the House or the upper House of Lords. They could check British. I mean, and they would use the phrase judicial independence. We tend to think that judicial independence is with minimal to no checks. So I think there's a slight, it's interesting to me that they both Federalists and Anti-Federalists use the phrase. I mean, they both want judicial independence, but Anti-Federalists want a few more checks than that they don't see in the
Well,
Constitution. So the phrase is there. It's just the definition and how it would operate is different.
I would have students look in Article 3, and I think, boy, I forget the chapter and verse, but in Article 3 there is the exceptions clause, right? And Congress still has a lot of power. It's constitutional. And it's been tried a few times, but it could be kind of in this day and age, it could be quite the political weapon. But in Article 3, Congress has the power to exclude certain cases from purview of the court, and that's the exceptions.
Appellate cases.
Yeah. So, if they want to say, okay, the court can't hear cases, say, on reproductive freedom or, things to do with the LGBTQ plus community, the Congress could do that. And then there have been attempts in history for certain congressmen to try to sponsor legislation. None of it has ever gone through because, again, in this day and age of political warfare, when one branch and one party then ends up controlling, Congress, then they're going to limit the court.
Just a quick check. Hasn't that clause been implemented twice? One with the Military Reconstruction Acts, and secondly with post 9/11 acts. I thought they took away the appellate purview in both of those instances. And that might be something to look up, students. That's what I've always thought, but that it's been very limited in its use, but it has been used a couple of times in our history.
Yeah, David, I don't know. And again, students, you might want to check on that. But it's
it's
twice.
Article 3, Section 2, where it's found. I wanted to check in with Mike to what you said, Chris. Chris said, Mike, that the rest of the world, the constitutional democracies, have progressed maybe beyond us when it comes to the role of the judiciary and courts in their system. Do you agree with that?
Well, I would say that progress beyond is kind of a subjective. Like I'd want the students to think about it and make up their own minds. I would say that we are the only system in the world where basically judges can serve their entire lives. Now, it doesn't say that, it says under good behavior, but it's effectively meant their entire lives. We're the only democracy in the world that has that rule in place. And also our process of choosing, like the advice and consent, is a purely political way to nominate and to get justices and judges there. Most other democracies in the world, they rely upon elected officials, but they also rely upon professors or lawyers, or it's a much more sort of wider group of people who get a say. We kind of do that in the way that the ABA will put out, a grade of someone, and the Federal Society is doing their lobbying, but that's not taken as seriously, or it's not as routinized as other places. So yeah, we are unique, definitely in the 21st century in terms of how long our justices can stay.
Well, even if you look at, like, say, the Colombian Constitution, they created a powerful constitutional court. But the thing is, it's also relatively easy to amend their constitution. I know Mike can speak to the South African court because he spoke about it before, and how they have different courts for different issues. Is that correct, Mike?
Well, yeah, they have a constitutional court that's only like constitutional issues, like you were saying earlier. Yeah.
And there's other courts for statutory stuff.
Yeah.
Yeah. So and those are modern. Those are more modern. I don't want to say contrivance, but those are more modern in terms of looking at how to operate the judicial system.
Yeah.
So, Professor Moore, let's get back to the beginning, and that is the convention and the ratification debates. What specific fears did the Anti-Federalists have about the proposed judiciary that came out of the Philadelphia Convention? What were their specific issues, problems?
Well, I jotted down 1, 2, 3, 4, 5, 6. One concern they had was the jurisdiction problem. There's a couple of Agrippa essays that deal with this. In other words, would this federal judiciary usurp obliterate, wipe out, severely limit state courts. So that comes up. In fact, I would if there's a problem, I think in the We the People text, it overemphasizes the judicial review piece that the Anti-Federalists are concerned with. They're more concerned about usurping jurisdiction. A second problem that Anti-Federalists have is the issue of what I call what Brutus calls judicial sovereignty. And Chris's point is well taken. Everybody on both sides of this debate, they know judicial review is going to be there, but there's a distinction between judicial review, which everybody's comfortable with, but Brutus is making the argument that there's no way to check really bad decisions. Judicial sovereignty. So that comes out of their discussion, Brutus's discussion about he fears the equity type case. He's Brutus smells a rat with the equity case clause in Article 3. Another problem for Anti-Federalists is just, okay, there's impeachment, but don't blow smoke in my ear. I think it was Luther Martin makes the argument in one of the Genuine Information essays. He says, I know impeachment is there, but it's unlikely that they'll ever use this. Or he says sometimes seldom used or ineffectually used. Quite prescient, I think. Brutus 15 lays out the concern about life term or good behavior, although there are many Anti-Federalists that are fine with good behavior because that's all over the state constitutions. So they're comfortable with that. But even Brutus says, yeah, but even in Britain, the House of Lords can check. So this is, you just can't. I think there's a little nervousness, but I don't think the visceral, the concern isn't as deep on this good behavior clause. Oddly enough, they're concerned about distance and location. There are many Anti-Federalist essays. There's a great one by Cassius 6. There's a great one from an anonymous essayist in Georgia called A Georgian. He lays out the argument. I wrote this quote down. It's really, I think it's great. He says, in this system, the rich will fly from justice. The poor will be unable to follow them to distant courts. And at this rate, I am confident you will establish a government which will be lasting and a blessing to ourselves and generations hereafter. I doubt that. So, how far will Farmer Joe have to go if he has a federal case, and will Farmer Joe go? Because there's nothing that says that the Congress has to create lower courts. So there's a great suspicion about the geography piece. And lastly, and I haven't ranked them in order of concern, but this last one here is very concerning to many Anti-Federalists, is the appellate system of the federal courts really smacks in the tradition of local juries, because there aren't juries at the appellate. These are just judges that are hearing cases. And that, obviously the Supreme Court is the ultimate appellate court. And so for those that are steeped in the British tradition, local juries are just next to, sacrosanct. So anytime there's a case, a trial that goes on without a jury, that's going to be a big concern for the Anti-Federalist. And there's Luther Martin and Generation X. Genuine Information 10.
I just got lost a little bit, Tim. Are you saying that appellate courts in their original creation were trial courts that determined guilt or innocence or civil? I'm a little confused there.
Well, it's a little disingenuous on the Anti-Federalist part, because state Supreme Courts they're juryless too. But that never got in the way of an argument, bolstering your argument with a constitution that is, the jury is totally not in the text. It's not there. So they see these and they rail against the Supreme Court is a juryless court. And they doubt that the Congress will actually create lower courts, but even if they did, they would be juryless.
Oh, okay. All right. Thank you.
And just back to the impeachment thing too for students. It's Jefferson and the Jeffersonian Republicans or Democratic Republicans that go after Sam Chase, justice on the court in 1804 because they tried to impeach him, and that fails because you know that they're going to come for Marshall next if they're able to get Sam Chase, but they were not able to get Justice Chase, and so they never went after Marshall.
There's Luther Martin's quote here on impeachment. He's talking about the presidency primarily, but in Luther Martin wanders around the universe usually in his speeches. But
well, because Luther was probably doing this.
Yeah. He says there's little probability. He's talking about impeachment. There will be but little probability of this ever being used in impeachment or conviction. And if so, it would be of little consequence whether he was impeached or convicted. You just you can't read this stuff without going, I wonder, is there any modern application there?
So, Mike, the students are asked to deal with a quote by Justice Jackson, where he says, "We are not final because we are infallible, but we are infallible only because we are final." To what extent do you agree with Jackson on this, I guess, human insight and institutional insight? Is it accurate, in your opinion, to identify the court as the final say?
Well, before I answer, I just want to say reading that quote is like a flashback from my logic class in college. And I just know that there's like
Wait, they teach logic and ethics in law school? Oh, okay.
no, this was an undergrad,
Oh, wow.
but it was like, last century. So, I don't think I do actually agree with Justice Jackson saying, and I guess I would say I don't think, look, I think institutionally, the court has said in Marbury, I know we're going to get to that, the court has said we're final. But we know that there have been over time precedents that have been overturned. Now, to a generation living at the time of Plessy, right? It was final for them up until you get into the changes and with Brown and other cases that are going to start, maybe not to overturn Plessy, but to overturn the spirit of Plessy. So I get it. There's some time lag there, but precedents are overturned, despite the fact that we don't pass very many amendments, that the power is with the people to pass amendments that could always be the final word. We know that Congress can act if the Supreme Court is interpreting statutes in a way that the Congress says you're just missing the boat. The 1964 Civil Rights Act, in a lot of ways, was trying to undo the way the court was interpreting the 1883 Civil Rights Act. So, and then finally, I do think that I don't know. The people are sovereign. The people are sovereign through the Constitution. So to the extent that there should be conversations on this, and while judicial independence is very important, I do not want a court that is just doing a poll on what the American people want. I do think that as new generations of Americans kind of are living, that they ultimately will have the final say, I think, because I believe in a kind of a living constitution. So I disagree with the back end of his statement. And then the front end, we are infallible only because we're final. Like infallible, like they're incapable of making a mistake. I don't know if he was being a little tongue in cheek or what he was doing, but no, I kind of disagree with what Jackson was saying.
Well, let's bring a Kavanaugh in on this, Chris.
Well, if you go back and read the whole quote from
well, that wasn't on the assignment.
I know, but students, please go back and look at the quote from Brown versus Allen, and what Jackson is saying. He right before that he talks about, we overturn lower court decisions. We're just the last stop on the food chain. And he says if there's a super Supreme Court, he uses that term, super Supreme Court, they would probably overturn some of our decisions. So he says we're not, so that whole idea that we're not last because we're infallible. We're infallible because we're last. We're the last stop in your constitutional shopping, so to speak. So if there was a super Supreme Court, they would overturn some of our decisions, but there isn't one. We're it. So
I can't help but think of a friend, a mutual friend of all of us, or former Justice Supreme Court of Oregon, Sue Leeson. She always said, this judicial, this federal Supreme Court, they decide stuff all the time, but in a lot of ways, it circles back around through state courts. Those decisions circle back through state courts. So uh, even this analogy of the last stop, I think Sue would challenge that because it does trickle back. I think Dobbs is going to be a great example of states trying to address it either legislative or through their courts. Um, so I like Mike. I think it's a bit of a hyperbole, because I think Sue might be right. It does percolate back to states.
Well, Chris,
but sorry, it only percolates back if the 9 people in DC will let it percolate back.
Right.
that would be 5 of the 9.
Yes,
Right.
thank you.
I like,
Yeah,
I like
but
the idea
so
of-
Chris, let's build on that because Mike kind of talked about, and I was thinking about this. I can't think of another case unless it deals with really some minutia that I'm just not interested in, other than Marbury, in which we can say, oh, they were the final arbiter. Because even constitutionally, that's just not accurate. And I think Mike touched on this. And you've done far more professional development than I have. And I've always been amazed when I deal with a lot of teachers who that's what they teach. The court has the final say on what the law is. And you want to say, well, it depends on what kind of law. Is it a constitutional law? And maybe it doesn't depend. If it's a constitutional law, well, the people technically in Congress through the amendment process have a say beyond that. And if it's a statutory law, well, we know that Congress and, depending on how the court writes it, can deal with that law. So why do you think,
Or administrative law.
okay, so why do you think, Chris, that's the dominant point that teachers teach is that the court has the final say? What's happened here in civic education?
Well, first of all, administrative law, not necessarily now, considering some recent decisions. Administrative law might have gone by the wayside. Who knows? We'll see. But I think it's just because, let's be honest, David, and I'm not trying to offend any teachers that are watching our program, but most teachers don't have the time to get a little bit deeper into the weeds like we have. I mean, we've been doing this for a long time, and we understand the subtleties. And I think in our last program, you were the king of the close reads. Yeah, that laser focus you brought to that last question. So I think that it's that way because it's the easier way to teach it, as opposed to going back and taking a look, say, well, really, folks, the Supreme Court is not the last stop. And Mike said it, ultimately the people are supposed to be sovereign. James Wilson may disagree. Wilson said the last time the people were sovereign is when they ratified the Constitution. After that, the Constitution became sovereign. But I think that's maybe why that is. Just because it's what that's what they've been taught, and it's easy. So we can say, okay, the Constitution, the Supreme Court has spoken, and that's the law. I remember, Sue Leeson, I used to steal part of her shtick is like, the 9 justices go into the cave, they consult the skull, and they come out and say, this is the skull has spoken, and this is what the law is, right? So it's that mysterious kind of unknowing. And so this is what ends up getting taught. But we know, and hopefully I'm sure many of the students that will end up watching this program will know that it doesn't stop, on those coming out of those marble steps in the Supreme Court building. It goes back to the people, and we get to, we and our lawmakers should be able to decide. So, but I think that's why it gets taught that way, if that's answering your question.
Well, and again, I'm not going to blame I'm glad you brought it. I'm not blaming the teachers. As I said, what happened in civic education here, and it seems to me part of it is quoting Marshall and Marbury. That's part of the problem is, he says, we are the ones who determine what the law is, and we kind of leave it at that, which naturally leads to this conclusion, I think. And maybe both textbooks and professional development needs to take that one step further, because I believe Marshall even understood their role within
Well,
separation of powers.
I mean, he is the only guy that's got his whole complete statue in the Supreme Court building, right? He gets the whole chair to himself and not just a bust. But a friend of the program, David Adler, who's a brilliant law professor, and he talked about Marbury actually being a setup. And he
Yeah.
teaches Marbury as it being a setup case by the Federalists to make sure that third leg of the bar stool I alluded to, judicial review, gets established in this case. And to listen to Professor Adler explain that is fascinating. And the idea that the most important case in Supreme Court history could have been contrived.
Can I
Go ahead,
add,
Mike.
yeah, just one more thing. We talked about this in a previous program about this idea of a separated system sharing powers. And it seems to me it's maybe relevant for the students to think through that setup, because I think both the Anti-Federalists and the Federalists would expect the leader of an institution to push as hard as he or she can to get power to that institution. I think that's to be expected. Like, we shouldn't be surprised at Marshall, just like we shouldn't be surprised that a president claims they have a mandate after an election, or that the Congress says we're the only body that represents all the people. Right? It's supposed we expect that, but I think where that leads us, that's just the first part of the dance, right? It should be that if you have this institutional logic, that Congress as a body and the executive as a body would have something to say to the court in terms of a Marbury. And I think they did I think there has been this ongoing conversation. And then I think the people as in civil society are involved in as well. So I don't think it's surprising Marshall says that we have the final say. And I don't think it's surprising what other elected officials say. I think it's just part of the sharing of powers, and that there should be ambition should be met to counteract ambition. Now, I know we're not there right now in 2025, just because of the way the influence of political parties, but I think in the design of the machine, that was the way it's supposed to work.
Well, doesn't that, Mike, however, I mean, the fact that it's become such a cemented aspect to our constitutional culture, it seems to me, doesn't it undermine democratic movements? That doesn't it, in many ways kind of act as a deterrent to citizen action, because oh well, the court has spoken and there's nothing we can do about that.
Well, I was thinking about this actually a couple minutes ago. Um, when Rosa Parks sits on that bus, is would she sit on the bus if she thought what the court said in previous cases was the final say? I mean, by doing that, she's part of the constitutional conversation. She's basically, or read Letter from Birmingham Jail, right? It's this idea like it does not make citizen activism impossible. It may make it riskier and it may make it harder, but I think it's all part of the political culture that has a role to play.
Even Lincoln addressing Dred Scott, it obviously did not like Dred Scott and like the opinion, but he said, this is the court, and we have to respect that opinion. Doesn't mean we're going to remain silent on it, but that is the opinion we have right now.
I can't help but think of there was a fantastic book written by Larry Kramer back in the I think maybe 2003 or 5, somewhere in there. His thesis was exactly what Mike is talking about, that there is Kramer's thesis is there's a slow, gradual popular constitutionalism. The rattle and hum of the populace will eventually influence court decisions. It's a really interesting book, and he tracks through the early 4 or 5 decades of American history. And so he espouses it's not immediate, but the slow, gradual drip, drip, drip of what the people think within the constitutional framework does have influence within the court. And it's kind of unsatisfactory for those kind of caught in the middle of waiting for movements to come to fruition. But remember, we have we kind of have an anti-democratic constitution to start with. So
I don't think you need to say that with caution. I think that's pretty blatantly understood.
Well, I mean, the history of the 80s was there's too much democracy. So, I mean, to expect a rule book that's gonna embrace democracy is a pipe dream. So,
Well,
I would
is it
recommend Kramer's book, certainly to teachers, on this notion of can we square that peg, popular constitutionalism and judicial power?
Well, you provided a great transition. So let's talk a little bit more about this rattle and hum of the populace, as Kramer or you describe. That seems to imply that there is an implication. Imply that there's an implication. Yeah, okay. It seems to imply that there is an understanding that public opinion and popular will has a role to play in judicial understanding, not an immediate, but over a period of time. What I'm just wondering if you, and I know you don't like to do this, but if you could speculate, because the kids are asked to deal with this role of public opinion in judicial understanding. I'm wondering what both the Federalists and Anti-Federalists, what they would think about that. I mean, my simple understanding is the Anti-Federalists would give thumbs up to public opinion, and the Federalists would be a little bit more hesitant, but that maybe is too simple. How can you help me out on that?
Well, I mean, yeah, you're asking me to speculate. Let me grab my Ouija board here
I know.
and come up with an answer real quick. But uh, at the time, all right, I'll come clean. Students, um, you need to evaluate Fed 78 because Hamilton goes through this logic. Mike talked about like he's
A
not buying.
class you had to take. Yeah.
No, well, Mike wasn't buying Jackson's logic. You need to ask yourself, do you buy this argument that Hamilton's argument that the court articulates the people? And that's essentially the people created the Constitution, and we now speak for the people. You need to evaluate that statement. Well, you probably can guess my view of that, but
You sound skeptical.
a little bit, because the Anti-Federalists pounce all over that. So they're not buying this. I mean, the Anti-Federalists, one Anti-Federalist even proposed that there should be a commission to review all Supreme Court decisions, kind of like the New York Review Board. They were suspicious, because the Federalists are like, relax. The standards, saw is that they're thinking of you, folks. They're thinking of you, the people, when they decide stuff. Well, and good and virtuous judges will, let me see, will keep democratic principles in mind. Yeah. Impeachment will work. They have to pay attention to the people because the impeachment is this stick that's going to chase them around and scare them. Well, it was John Smiley, I think, in the Pennsylvania convention. Well, the Anti-Federalists are playing the BS card to all of that. They don't trust that stuff, and they don't see enough democratic principles, or certainly democratic processes, potentially in this. So I don't know ultimately, what they're going to say, but how it plays out, in my view, the Anti-Federalists are much more honest than the Federalist argument about trust this democratic court.
So another pet peeve I've had over the years, and maybe you guys can take me to school on this, but the number of times I hear that the court is set up to protect minorities, and that the romantic age of the Warren and Burger courts, are exactly what the court was set up for. And I've always had a little bit of problem of that, because my understanding, no, they're not there to protect minorities. They're there to interpret the Constitution. And sometimes the Constitution doesn't protect minorities. How do you give me feedback there?
Yeah, there's a great book on that too, David. Lucas Powell, the Warren Court and the Warren Court and something. And his argument is that they are reading the polls. They are reading the tea leaves. They got their ears to the ground that there is a liberalization of democracy that's occurring post-World War II, and the court had better get in line. It's a wonderful book. I mean, so this champion court doing all this virtuous stuff. Okay, great. Another way to look at it is they understand the trajectory of post-World War II liberalism, and so many cases are within that framework. It's a Lucas Powell wrote a book to that effect. In other words, there's this popular constitutional understanding that is slowly over a generation coming through in liberalized decisions that the Warren and Burger Court were a part of.
So if I understand the logic here, the court, the Plessy decision is in many ways a reflection of the culture at the end of the 19th century. And so you couldn't have seen a Brown decision based upon that. And therefore, the Brown decision is a reflection of political culture or culture. But we have a problem with that because Frankfurter will only sign on to Brown if they give the Southern states, all right, some latitude in implementation. And he says verbatim that we may be going too fast here and we could cause major disruption.
Yeah.
So I wonder about that kind of.
This is where Chris chimes in with the "what's changed" speech. You know, what has changed between Chris? Go ahead. You're much better at this than I am.
Well, I was thinking actually of Lawrence Tribe, who's a Yale law professor, who's retired, and I remember when President Bush the second floated the trial balloon of Harriet Miers as a nominee for the court, who was his attorney out of Texas. And Professor Tribe said something that stuck with me. Back to your original question, David, that she has never had the Constitution as a client. So the client, the court's client is the Constitution, not minority rights. But back to what Tim's talks, I mean, what changes from Plessy to Brown? The society changes. There are no new laws. We have the 14th Amendment, and it's just we have society changes and members of the court change. My goodness, go Bidas to West Virginia v. Barnett.
Yeah, but that's such a quick turnaround. Did they just not read the culture in Gobitis?
Well, I'd cite the commerce cases coming out of the 30s. There, it took a while for the court to come around on broadening out the definitions and understanding commercial power to get to the decisions they did. So I think the cultural piece, Chris I've thought about this phrase that he's used quite a bit over the last couple of years. And it's to this point, well, okay, does the culture drive, or the other way to ask it, does the court really listen to culture? Well, they claim independence, but I think there's a couple pieces of scholarship that indicate that they have their ears to the ground more than we give them credit.
Yeah, but they're just like us. I mean, I always think of culture as like the fish doesn't know they're in water. That's just where they're at, and the water is the culture. So I don't even know.
Did you learn that in that logic class?
Yeah, no, this was much later. This is like this century I learned that.
I'm sorry, Mike. Go ahead.
It's like
The fish doesn't know it's in
what
water.
did one fish say to the other fish? Like, how's the water? And the fish says, "What's water?" That's the joke.
Yeah, could you please go on? I'm still a little bit confused about this. Build on your logic.
I just think the judges, they're in the culture that they're in. They don't need to put. I think they can put their ears to the ground, but they're also going to just be influenced about what they're seeing and what's around them. And I mean, Dave, when you asked this question about minorities, I was going in a completely different direction. I was like thinking of the court as, we have this anti-democratic kind of constitution, and what's the minority that the framers maybe are most concerned about? It's going to be people with property and this fear from the Greeks that if you have too much democracy, the majorities are going to take it over. Now, and we see that all up through Lochner, right? And it's just, so I don't know, maybe the court does in a meta way see itself, the minority changes with Caroline products. But it is that maybe that institution that is there to make sure that the democratic impulse does not then overtake someone's rights, and it changed from maybe economic rights to more civil and political rights. And now maybe we're changing, maybe we're on this process of back to economic rights, or maybe we're just in a whole new frontier. Maybe it's the right of state legislatures to make up their mind. I don't know, right? So this idea about federalism, but maybe that's the way I was thinking about your comment, actually.
Well, David, back to your original question about the court protecting minority rights. I think that's where we kind of just backtracking. Of course not. It's not there to protect minority rights. Look what happens in Barron versus Baltimore. But look what the court says. No, sorry, the Bill of Rights does not protect you from state and local governments, right? It takes the 14th Amendment and incorporation, and so it's not until 1925 that we actually start protecting some civil rights. And if you look at some of the first cases that using the 14th Amendment, they're protecting corporations, they're protecting railroads. So the court, it's
right, but again, I mean, a classic one is the outrage, and again, it's a good debate, but the outrage that people have about Korematsu, and then, well, wait, the court's there to protect, and you're kind of going, well, I don't know, they're reading the Constitution within a context of how they understand it,
sure.
and yes, in hindsight, and we kind of go, whoa, that was bad.
Well, we say that was bad, but when Korematsu came out, people didn't say it was bad.
Right.
If you look at, I think you have to look at who was it, Murphy and Jackson's dissent. Those were very powerful dissents in Korematsu. Very powerful, very, very powerful, very, very strong today.
Right. Yeah.
But when that came out, I mean, it's kind of like the TikTok case that they just heard on Friday. National security versus free speech, national security versus, locking up people of Japanese descent. So at the time, it was like, yeah, well, we're at war. The government should be able to keep us safe, and these people, we can't trust them, so we're going to put them in.
But were they not reflecting a popular attitude amongst the American people in that decision?
Yes. Oh yeah, that's what I'm saying. Yeah. So people weren't wringing their hands going, "Oh, Korematsu was a terrible decision." And Korematsu was like, "Yeah, these people scare the heck out of us."
Yeah. So, Professor Williams, hopefully you've had a chance to at least read an article or look at it. In his end of the year report, the Chief Justice. Well, remember, Tim read all 496 or how many pages of Project 2025. So
950.
yeah, that one.
Tim,
So,
do you feel any better? Are you any better of a person?
I feel a little superior, yeah.
Yeah, do you? Okay, well, good. Take that down to the leaking tap. Tell them what's on page
well,
125.
this may be unfair, and hopefully all four of us together collectively can cleanse this out. But in the end of the year report, Chief Justice Roberts claimed that the judicial branch and judicial independence is under threat from both foreign and domestic actors, including members of the political branches. And I'm just wondering, what are your thoughts?
Yeah.
Do you think there's a reasonableness there on behalf of Roberts? And a lot of the criticisms coming from the left of center group because of Dobbs and other decisions, and some ethical issues on behalf of Thomas and Alito in there. But I'm just wondering about the reasonableness of his report and his crying wolf, some might say.
Yeah, no, I think it is. And I think for the students, it's going to be much easier for them to find domestic examples, maybe. And I'll share some. I know Chris and Tim have some, but it was this idea of foreign interference that I did a little digging on. And I found something. I'll put this in the show notes. There was a June 2021 report from the U.S. Marshals, and they noted that since from like 2016 to 2021, there was an 89% increase of threats, security threats, and inappropriate communications to judges, getting up to like 4,000 a year. And many of these are coming via internet trolling. A lot of it, they're pointing to Russia, right? But it's information getting out and claiming that judges or justices are being biased towards immigrants. That's one of the major tropes that is used. And in some cases, making up cases, in some cases, taking a case where the facts are there and then, and then exaggerating it. So with the foreign interference, I think that's that's what he's looking towards. It'd be Russia and China, the use of social media as a way to threaten the legitimacy of the judicial branch. And domestically, I think you could just look up quotes. I mean, after the federal judge declared what was being referred to as the Muslim ban in 2017, Trump referred to that justice as a so-called judge. Chuck Schumer came out after Dobbs and said that those justices, there's going to be a quote price to pay for their decision. So we've had politicians on the left and the right say things that would threaten the legitimacy, the independence of the courts. Now, Tim and Chris are probably thinking, yeah, tell me something that hasn't been happening since day one. And I'll let them fill in that history, but it is happening today. And I do think that at least in my lifetime, the breaking down of the norms of like it's okay for elected politicians to say things like that. I always go back with my students and tell them about the 2000 election and the way Gore handled that, right? It seems like it was like a different country we're living in when he stood up and said, I disagree with the court's decision. I don't think it's accurate, but I'm going to abide by it and I'm going to shake W's hand, and that's going to be that, right? No, nothing else on the side, nothing talking about the polarization or partisanship. We are so far removed from that. It seems like elected politicians, both Republicans and Democrats, are much more likely now to just call out the justices and claim that they are acting in a political way rather than in an independent way. And I think that Roberts is right to be fearful of that.
Well, two things. One is, uh, you know, members of multiple institutions, whether it be Congress, um, cabinet members, administrative agencies, the threats to government officials at local, state, and national level have increased exponentially
Yeah.
over the last 10 years or so. And I'm a little bit, cynical about pointing out, well, to the court that they're the only victims of this rise of hate and threats and stuff like that. But I am wondering what you think. You remember Obama in his State of the Union address criticized a court decision. Do you think he was attempting to undermine the legitimacy? Because remember, it was famous because Alito was in the audience, and the cameras panned to Alito, and he's shaking his head no in physical disagreement with Obama. I'm just wondering what you think about that. Did Obama undermine the legitimacy of the court by publicly criticizing their decision that they had made?
I have to go back and look at what he said, but I can't say this. I can't say it's one thing for an elected official, I think, to challenge the reasoning or to challenge maybe the logic or that you misread precedent. I'm guessing, knowing how Obama framed his arguments, I'm guessing it was like that.
Yes, it was.
And attacks of like, this person is stupid, or this person doesn't know anything, or this person has a bias against me as an elected official. I think that's a different kind of attack that doesn't have a place in our political conversations, I don't think, even though it
Okay.
has from the beginning. I think criticizing the reasoning of a court, I think that's within bounds. I think it always has been.
Don't
Okay,
you think
Tim and
that
Mike,
the
take us to a
undermining
history
of the
class. Or
court,
Tim and
though,
Chris.
starts? I have a tendency to think the undermining of the court really has started with the confirmation process. The whole circus-like ridiculousness of the confirmation seems. I don't know that that's elevating the status of the courts or the Senate, certainly immediately. So I think it's more than just once they're there making decisions. I think there's a front-end nature to this undermining of the legitimacy.
But to Mike's question, is this something that has always been so that the court being in the political process in an ugly way sometimes is just the nature of our system?
Well, I go back to the founding, and there was a lot of politicking in the early court and the federal judiciary, and but the coverage, it just really I guess I'm going to jump on the bandwagon of beating up social media here, but the ability for everybody to be a political observer and commentator, because we have these things and an overinflated sense of our knowledge. It's the Dunning-Kruger effect. We think we're experts, you know, and usually the most ignorant people think they're the most knowledgeable. So I think there's just way too much assumption about our knowledge and what we know, and I don't. I don't know the sign of yeah. Well, anyway, I'm not going to get on that train. But.
Chris?
I'll push back here.
Oh, okay.
I think Chief Justice Roberts needs to put his big boy pants on.
Okay.
It's like people have criticized the court since the court's been in existence, and you better clean up your own house first, right? There's no thing other than a Congress, which we know is a limp organization at this point in time, to keep the judiciary and the presidency, to keep the judiciary in check. When you have members of the court that have lied, and I'll say that on this program, that have lied in their confirmation about settled law, right? When you have members of the court that have not been forthright in disclosure on who's been giving them expensive trips and gifts and paying for your mother's house and all types of things. When you have people on your court that have done these things, you need to clean up your own house, because you're allowing this to happen on your watch, and you're wondering why people are criticizing the court for being not ethical, because it clearly looks like it has not been ethical. So you might want to check in the mirror first, or look to your right or look to your left of the people that's sitting at the dais with you, in terms of you want to be above reproach, then you should be above reproach.
So what would that look like, Chris? I'm curious, because to me, the solution is Congress has the tools to deal with these problems and they don't. But what do you want the Chief Justice to do? He's got no authority over the other members.
Don't go pissing and moaning about stuff when people want to try and come in and use their congressional power to control the court a little bit more, because the Congress does have the authority to do that. They could issue some type of ethics standard. The Supreme Court could issue an ethics standard, because members on the court right now, Justice Kagan, it comes to mind, believes that this thing that they just came up with a few months back was just it's a parchment barrier, because there's nothing in there. So we're going to take the word of certain people that have received gifts from people and have not recused themselves in cases that have come before them. You wonder why the courts that used to be, polling, public opinion polling in the presidency is, hardly ever above 50% ever. Congress is lower than whale poop at the bottom of the ocean in terms of approval rating. And now the Supreme Court has really sunk down in terms of, that used to be the one institution that was, people kind of believed in, but now they don't. And part of that, I think Tim is right, the confirmation process and some of the norms that have been upset in that, not necessarily legal, but certainly normative behavior that we would expect from people in government. So, I mean, Chief Justice Roberts, don't complain about, you got a lifetime job, buddy. You got a lifetime job.
Love it. All right, we have come to the end of our discussion here, and as per our tradition, we'd ask our scholars to provide some final thoughts and insights and recommendations for students and teachers as they prepare for their hearing. So, Professor Williams.
Yeah, I would urge students with this question maybe to what Dave said earlier, to challenge sort of maybe what you have thought the entire time, to test some arguments with each other about maybe the court is not and should not be the final say. And what does that look like? And why is it that we have some moments where it seems like there's more opportunity for citizens to engage in that conversation, other times when there's not? So I do think I would encourage you to think about what is your role to play in these decisions that are being made by the Supreme Court.
Professor Moore.
Yeah, I think if you're, I'll reiterate those two books that I mentioned about this, trying to explain, is there popular input, and to what extent, if there is popular input, does it influence court? Lucas Powell, Powe, and Larry Kramer's The People Themselves. I would really recommend teachers read those. I wouldn't unleash them on your students, although maybe. But definitely those two go to the heart of the matter here, this dilemma actually that we have in our system. And also the Brutus essays 11 through 15 are your kind of go-to critiques of the Federalist claims about the courts. So,
Professor Kavanaugh.
I'm going to throw one more book in there too, and I have Tim to thank for turning me on to this book. It's called The Hollow Hope by Gerald Rosenberg, which is a fantastic book. The original came out in 1991, but he's had multiple versions since then because he's got it updated with case law. And his argument was that durable public, political, and social change is nearly impossible through the courts, right? And he talks about dynamic and constrained courts. And there are interesting concepts within that about what a dynamic court and a constrained court is. And I think this goes back to David's question originally about Marbury. Other than Marbury, is anything actually settled law? And it really isn't. And I would suggest you take a look at Rosenberg's book, The Hollow Hope, about people putting, well, the courts will fix it, right? Well, that's not a good place to rest your hope, so to speak. And again, I think take a look at Jackson's quote, and he's not saying that they're infallible. He's just saying we're last, but are they really last? We've discussed that on this program this evening. What other avenues are open to people? And I love Mike's point about Rosa Parks. Would she have sat down on the bus if she thought it was done? If there was not a way to push that forward. And a lot of the civil rights warriors of the civil rights movement, as well as modern folks, right, to continue to push and push and push, because we know that society changes and the court changes. That will happen. So I would take a look at that book.
Well, thank you, gentlemen. A wonderful discussion on the judiciary. Next week, I can guarantee two things. One, well, I can't guarantee that I'm going to be prepared because it may take me a week to work out Mike's fish and water logic problem here. I'm still a little bit baffled about that and its whole fundamental meaning there. But I'm going to be working on it. And secondly, I know because we're going to be looking at Unit 6 next week that I'm going to be wearing my big boy pants there to make sure that Kavanaugh doesn't rip me apart here. We're going to be looking at this notion of polarization and shared values. And I promise you, students and teachers, I'm going to ask historian Moore if there's ever been a moment in which we have shared values as Americans there. So until that moment, take care of yourself and study hard. Peace, love, yogurt tacos. Bye-bye. Bye bonds.